Good afternoon, everyone, and thank you for joining this Use Laboris webinar. My name is Alessia Perez, and I will be facilitating the session for you today. Today's webinar will be given by a set of panelists, all from different member firms of Use Laboris. And today we have lawyers from Belgium, Sophie Maes, and Italy, Ornella Patanet, and pay reporting lead from UK, Tom Hayes. Before we kick off the session, I would like to clarify a couple of points on the housekeeping side. If you have any questions throughout the session, you can use the Q&A tab to send your question to us, and the panelists will answer as many as they can at the end. You can, of course, also reach out to the panelists via email after the webinar. And regarding the slides, those will be available on our website, along with the recording after the webinar, and will be shared with the attendees via email as well. I will now turn over to Sophie from Claes & Engels, the Belgian member firm of Use Laboris. Go ahead, Sophie, you are welcome to start.
Yes, thank you very much, Alessia, and also on my behalf, welcome to our webinar, where we will discuss today the Pay Transparency Directive. Just perhaps as a brief introduction, how did we structure this webinar? Well, we have divided it in 3 sections. First of all, we will have a look from a broad level what the Pay Transparency Directive says. Then secondly, we will dive in some more key practical considerations. And then lastly, we will share with you some tips and tricks on how to get ready, because if there is one takeaway that we absolutely want you to get out of this webinar is that don't wait until 2026, but you should start preparing now. So yes, if we can move to the next slide. So the next one, the Pay Transparency Directive in a nutshell, what is it all about? So if we talk about the Pay Transparency Directive, then we talk about equal pay for equal work or work of equal value between man and woman, something which obviously is not new, as we all know, in Europe. It's one of our fundamentals that we have seen in our treaties. We have important case law of the European Court of Justice in 2006. We also have a gender equality directive, but the reality is that in 2021, on an average, the gender pay gap was still at 12.7%. So that is the reason why at European level, the Commission thought it was high time to take some more measures in this respect in view of closing finally this gender pay gap. And research has also shown that one of the 3, at least legal obstacles that were found as a cause for the gender pay gap were, first of all, the lack of clear definitions and uncertainty in relation to some concepts. Secondly, also the lack of transparency, because simply employees did not know or do not know what their counterparts are earning. And thirdly, also research shown that in some member states, there were also some procedural obstacles for victims in order to make equal pay claims. And actually, that is what the Pay Transparency wants to address, to take measures to work on those 3 areas. So we will, of course, dive into more detail in a few minutes. What is important is that the Pay Transparency Directive was adopted in May 2023 and has to be implemented in local legislation by the 7th of June 2026. To who it applies? Well, it applies to both public sector and the private sector, and it applies to employees. Employees are defined in the directive as the persons who have an employment contract or who are in an employment relationship with a company according to national law or practice. So we need to look at national law of the different member states if certain persons are considered employees. And this could be, and the examples that are given in the directive itself is that it can be extremely broad, including both full-time, part-time employees, also fixed-term contracts, platform workers, trainees, etc., as long as they are considered employees under national law. As we will see, there are some provisions that also apply to job applicants. But the pay transparency itself does not apply to self-employed workers. But what is important also is that the Pay Transparency Directive, as you see as a bullet point on the slide as well, it also only provides minimum standards, minimum requirements. So we will still need to look at how member states will implement the different obligations. The Pay Transparency Directive, the measures that it foresees is applicable to all employers, with so only if you employ only one employee, some of the provisions are applicable to them, with one exception, the reporting obligations, as we will see them, they in principle only apply for companies as of 100 employees. But again, these are the minimum requirements. We will need to look at how it is implemented into local legislation, knowing also that the directive contains also a standstill clause, which means that if local law already provides something which is more advantageous, then this cannot be removed. And this can be in particular important in relation to the thresholds for the reporting obligations, because in some member states in the EU, there are already today reporting obligations for less than 100 employees. But again, and I think really this is our key takeaway, companies should start preparing now. So if we move to the next slide, so very high level, in a nutshell, you find here summarized the different provisions that are included in the pay transparency. You see several squares, but actually we can divide them in three pillars corresponding to the three concerns. So first of all, on the top, you see that the Pay Transparency Directive wants to give definitions of some key concepts. And very important here is the concept of pay, because we talk about equal pay. Question is, of course, what is pay? Well, pay includes everything. It's the total remuneration package, and it is defined under the directive as not only basic salary, but also benefits in kind or in natura, which are then being referred to as a variable and complementary components of pay, which an employee directly or indirectly receives in respect of his or her employment. So examples that are being given is extremely broad. Again, it refers to overtime pay. It includes also bonuses. It includes also travel facilities, very important in Belgium for a company cars. Then also sick pay, dismissal indemnities, compensation for training. So really the entire compensation package for employers. Other very important concept is a concept of category of workers. A category of workers are workers that are performing the same work or work of equal value. How we will need to determine that is something we will look at it in more detail, and Tom will explain that. But it's a very important concept because, as we will see, several employees have several rights in relation to or to obtain information in relation to the category of workers they belong to, and also reporting obligations. So that's the first set of a first pillar is definitions. Then a second pillar contains some mandatory transparency obligations, which we can also divide into, first of all, a set of rights to employees to get information, rights to get information before the start of the employment, but also during the employment, something which Ornella will also give more explanations about. And then also we have as already indicated, a reporting obligation as of 100 employees. We will see also that if, as a result of this reporting obligation, there is a gender pay gap of more than 5% within a category of employees, employers will be obliged to go do, together with the employee representatives, a joint pay assessment. So that is kind of those four blocks summarize the mandatory transparency obligations under the Pay Transparency Directive. And then we have a third pillar, which refers to that last obstacle, the procedural obstacle, where we see that the Pay Transparency also wants to strengthen remedies and enforcement in a very important way. So that is actually in a very big nutshell what the Pay Transparency Directive stands for and what it includes. So perhaps very shortly before I move over to the more practical aspects, to the next slide, where I just want to give some more information about the reporting, because we have seen reporting obligations apply as of 100 employees. It will be introduced in a more gradual way, but the reporting actually includes 7 statistical formulas that you see on the slides. The first 6 relate to the company as a whole and relate to the gender pay gap, but also the median gender pay gap, also based on complementary and variable, so components of pay, also portion of female and male workers that receive complementary and variable components and of pay, and so forth. Well, the result of those formulas will need to be communicated to the national monitoring body, who will publish that information on an easy accessible website, because the aim is also that stakeholders can have access to that information and make comparison between different companies, between different regions, and also between different functions. But then there is also in black a last statistical formula that must be calculated, and that relates to the gender pay gap between workers belonging to the same category of workers, and that information needs to be broken down between, on the one hand, basic salary, and on the other hand, the complementary and variable components of pay. This information must also be communicated, but that will not be published, but obviously it also needs to be shared with the employees and the employee representatives. The employer must confirm the accuracy of the information after consulting the worker representatives, who can also, or who are also entitled to have access to the methodology that is being used by the employer. And of course, they can ask questions, etc., and which must be answered by the employer within a reasonable period of time. If we then go to the next slide, I also already indicated or talked about the joint pay assessment, so that is the next step. So if we see that there is a gender pay gap of 5% or more in a category of workers, which cannot be justified based on objective and gender neutral criteria, and the employer has not remedied the difference within a period of 6 months after having submitted the report, well, then the employer will need to do an audit, a pay audit, together with the workers' representatives. Perhaps one thing which is important to highlight here as well is the fact of having a gender pay gap as such is not the problem, but the problem is if we cannot justify it based on objective and gender neutral criteria. So these criteria will be extremely important to justify any differences in pay. Result of gender pay assessment must also be available to the employees, to the worker representatives, and also be communicated to the monitoring body. In relation to the, if we can now move to the next slide, in relation to the reporting obligation, so everything in right to information and etc., everything enters into force in 2026. But in relation to the reporting will need to be done for the first time in 2027 over 2026 for companies who have more than 250 employees, and they will need to do it every year. Whereas for companies between 150 and 250, they will also need to do it for the first time in 2027 over 2026, but will need to do it every 3 years. And then for companies as of 100, they will only need to do it for the first time in 2031 over the year 2030, and equally every 3 years. But again, these are minimum standards. We need to look at local implementation if in particular the thresholds will not be lower in a given member state. So that is in a nutshell our first section, what the pay transparency is about. And now I give the floor to Ornella, who will go into more deeper details of some key consideration in practice.
Thank you, Sophie, and good morning, everyone. As Sophie already told you, Pay Transparency Directive introduces a lot of obligations for companies in terms of transparency towards candidates and employees regarding information on pay. Those obligations are for all companies, irrespective of the number of employees, and are effective immediately after the implementation of the European Directive in the different countries. They are obligations of transparency either before the employment contract starts and during the employment contract. As far as the obligations of transparency before the employment contract starts are concerned, job applicants are entitled to know the initial pay or its range based on objective gender-neutral criteria related to the position for which they applied. This is carried out to ensure an informed and transparent negotiation on pay through the publication of the pay in the job vacancy notice before the job interview. Candidates are also entitled to know what are the provisions of the collective bargaining agreements applied by the employer with respect to that position. But most importantly, at this stage, during the interview, the employer is completely prohibited from asking the job applicants about their pay history during their current or previous employment relationships. This represents really a big paradigm shift, since so far recruiters are used to ask candidates their current payslip and then build on an economic proposal depending on the current salary gains. In future, instead, this will not be possible any longer, and since the beginning, the employer must publish the salary related to the job position advertised. The employer is also required to ensure that job vacancy notices and job titles are gender neutral and that recruitment processes are led in a non-discriminatory manner. So moving to next slide, please. And so coming to the obligations of transparency during the employment contract, the employer is required to make easily accessible to their employees the criteria used to determine salary, pay levels, and pay progression. And those criteria must be objective and gender neutral. This means that those criteria shall not be based directly or indirectly on employee sex. They shall include skills, efforts, responsibilities, and working conditions, and if appropriate, any other factors which are relevant to the specific job or position. They should be applied in an objective, gender-neutral manner, excluding any direct or indirect discrimination based on sex. In particular, relevant soft skills must be taken into account as well. Going ahead, please move to the next slide. Thank you. So during the employment contract, employees are also entitled to an important right of access to data related to pay of other employees. This right of access must be very carefully regulated to avoid giving employees more information than what is required by the directive. Indeed, under the directive, employees are entitled to receive written information on their individual pay level and the average pay levels broken down by sex for categories of employees performing the same work or work of equal value. This information must be provided within a reasonable period of time that cannot be longer than 2 months from the date of the request. And if the information received is inaccurate or incomplete, employees, alone or through their employees' reps, are entitled to request details and reasonable clarifications regarding any of the data provided. And they are entitled to receive a reply with reasons and the requested details. Then the employer is also required to inform all employees on an annual basis about their right to receive such information, as well as the steps that the employee must follow to exercise that right. Employees cannot be prohibited from disclosing their pay for the purpose of implementing the principle of equal pay. I give you the floor to Tom.
So I will now be discussing the categorization aspects of the directive. And this is a really important element of the directive, and it's going to be essential for employers to understand how to properly categorize jobs. And I think it's important to know that categorization will be relevant to all employers, regardless of headcount, because while the reporting requirements for gaps by category only apply to those with a certain headcount, all employees will gain new rights to get the average pay of men and women in their category. And so if employers can't confidently and accurately categorize their employees, then they won't be able to comply with this new right. And that's why getting categorization right is so crucial. So what is categorization here? Well, the Pay Transparency Directive wants employers to categorize employees into those roles that are of equal value. And value here can often be misunderstood. It's not about the financial value, but essentially the difficulty and demands of different jobs when they're looked at in the round. And so this means that jobs that have similar demands and difficulty should be grouped together. So for example, an HR manager might be in the same category as an IT manager, a sales manager, an operations manager, but it really depends upon the facts, and equal value categories will differ across companies as the nature of roles differ across companies. The aim is to ensure that employees performing work of equal value are paid equally and they're placed in the same category. So how is it done? How's categorization done? And so to achieve proper categorization, employers will need to use a gender-neutral job evaluation method. And this involves assessing roles based on several factors, and the Pay Transparency Directive sets out a non-exhaustive list. As you can see on the slide there, we've got skill, so the level of expertise, knowledge, and abilities required to perform the job, effort, the physical and mental exertion needed to carry out the job duties, responsibility, the amount of accountability and decision-making authority associated with the role, and the working conditions. Is the environment in which the job performed particularly hazardous? Are there any difficulties? These are some of the factors that might form part of the job evaluation methodology. There may be others to consider depending upon the employer, the type of jobs that they have, and the sector that they work in. Categorization is not without its challenges. So I think one of the primary difficulties is the job evaluation is very specialist skill. It requires knowledge of different job evaluation methodologies, their strengths and weaknesses, and how they're applied in different cases in different sectors. And it's not something that anyone can easily pick up and do. It requires expertise and experience in order to ensure that jobs are being accurately assessed and grouped based on criteria mentioned above. And I think also important to state that although it's not quite fair to call job evaluation a pseudoscience, it is reasonable to say that it's not a completely objective process. Different methodologies run by different people might all be capable of leading to different groups of jobs being categorized together. For many employers in the EU, it won't be a case of approaching job evaluation from scratch. Lots of companies, and I'm sure lots of people on this webinar now, will have existing job leveling in their organizations based on different methodologies. And so for them, the challenge is determining whether your existing leveling, whether that's sufficient for the Pay Transparency Directive. And so it's going to be really important to verify that these systems meet the requirements of the directive. And this needs to be done well in advance of it coming into force. In some EU member states, there are collective bargaining agreements that will be in place that will be categorizing jobs, and whether or not that's up to scratch for the Pay Transparency Directive is not clear. There is some uncertainty regarding the use of the categories from these collective bargaining agreements. Although at this point it might seem quick and easy to simply try to rely on these categories, I would suggest proceeding with caution here and not simply assuming that these CBA categories will suffice. The overriding point here is to ensure that jobs that are of equal value are being categorized together. And with that, I'll hand over.
Yes, thank you, Tom. If we move to next slide, please. No, exactly. Thank you. So another crucial point of the EU directive is the involvement of employees' representatives. Pay Transparency Directive introduces indeed lots of obligations on the employer to engage in social dialogue with employees' representatives, or rights of the employees' reps to ask and obtain information and access information on the organization and pay structure of the employers. The main examples of that are, for example, the fact that the employer agrees with employees' representatives on objective and neutral criteria on which pay structure must be based in order to verify whether workers are in a comparable situation in regard to the value of work. Then for another example is that employees' representatives are involved by employees in requesting clarification on the information provided by the employer on their pay or the average pay levels for categories of employees performing the same work or work of equal value. Then the accuracy of the information provided on the gender pay gap must be confirmed either by the employer's management after consulting with the employees' representatives. So again, a great involvement of the employees' representatives. Then employees' representatives have also an independent right of information regarding the gender pay gap. Also, if the gender pay gap is not based on objective and gender neutral criteria, as Sophie told you, employers are required to address the issue within a reasonable time frame in close collaboration with the employees' representatives. And also, based on the information gathered, the employer is required to conduct a joint pay assessment in cooperation with employees' representatives. And if there is an unjustified pay difference, the employer is required to correct such discrepancies within a reasonable time frame in close collaboration with employees' representatives. So as you may appreciate, all those rights of employees' reps are quite new for a lot of European countries, Italy included, because only in some countries, for example, as in Germany, you have a co-determination powers of employers' reps, while in most of the European countries instead, employees' reps have only a right to be informed and consulted, but not a right to access all those information, neither to cooperate with the employer in defining something related to the company's organization. So this new kind of cooperation introduced by the European directive must be managed before the entry into force of the European directive. Next slide, please, with Sophie.
It will be me, actually.
Okay, Tom.
So in this segment, I'm going to be discussing the reporting and the analysis requirements under the directive. And this is a really critical area that requires careful attention to ensure your Pay Transparency Directive compliance and also address any gaps effectively. So why is it going to be difficult? Well, reporting under the Pay Transparency Directive will be challenging for various reasons. So a big issue here is that where there are unexplained gaps by category, it will trigger a joint pay assessment, as we mentioned earlier on in this webinar. And this means that if the data shows significant pay disparities that can't be easily explained, then you'll need to work with worker representatives to conduct a thorough assessment of the pay practices of the organisation. And it's carrying out a joint pay assessment will be a big, complex job, which will require significant resources. And so you'll want to try and avoid this as much as possible. Workers' representatives will have a powerful role to play, and they will be able to interrogate you essentially on your gaps. And if they're not happy that gaps that are greater than 5% in a category of job, can be explained by reference to objective reasons, and they can't be fixed within 6 months. This is what prompts the joint pay assessment. So this is why you have to be really clear with how you've explained your gaps. And that's going to require some quite complex statistical analysis. It will need to include regression analysis. And so this is a statistical method used to quantify how much of the gap can be explained by objective reasons. Essentially, what you're trying to get to here is, say, if you had a 15% gap within a category, you want to be able to say, well, 6% of it is being caused by objective reason A, and 5% of it is being caused by objective reason B. And so what's left is less than 5%. And so because there's less than 5% unexplained gap, it doesn't prompt that joint pay assessment. And that's the point that you want to be able to try and get to. And that's how and regression analysis can help you get there. So it's going to be a key tool in this process. And as I said, it helps you quantify the amount that can be explained by objective reasons. But carrying out this sort of analysis, it's not an objective process. And that's because it involves decisions around model selection. So there may be dozens of potential statistical models that could fit your data, and there's not clearly one that is the best. There are arguments to be made about various different models, and the complexity of them and the fit of them. And as I say, not one definitive answer. But because employers need to be able to explain the methodology that they use and how they've arrived at the results they've got, that means that this type of statistical analysis can't simply be delegated to some sort of black box that spits out the answers. And that's because of all of this subjectivity around the model selection. Employers will need to provide representatives with a clear and, importantly, defensible analytical process for how they've got to their explanations. And so as well as having a detailed understanding of the process that you've gone through, I think it will also be important to consider training your worker representatives on the methods used so that you can have sensible conversations with them. This will help also build some trust and ensure that all of the parties have a clear understanding of the analysis, and essentially everyone knows what it is that you're talking about, and that can help you help get greater understanding.
Yes, apologies, I was still on mute. So next question is, because we have seen a lot of new obligations, a lot of rights. So what if we don't comply with the Pay Transparency Directive and the way it has been implemented in local legislation? Well, as I explained in the beginning, the enforcement is also an important part of the Pay Transparency Directive, because obviously if we have equal pay claims, that is around making the claim and obtaining the payment, but we also need to prove it. And if we then look at the Pay Transparency Directive, we see that many measures have been taken also to ensure that victims of unequal pay can obtain or can have access to court and also can obtain their damages. So what has been provided in order to make it easier for victims of unequal pay arrangements? Well, first of all, there is a full burden of proof if the company does not comply with the Pay Transparency Directive. So imagine that the company does not do the reporting, or the company does not provide the employees with the information that has been requested. Well, then there will be a full shift in the burden of proof in case of a unequal pay claim. So which make it again much easier for victims to have access and to obtain their rights. There's only an exception, or the directive provides for an exception if it is intentional, or also if the fact that you did not comply with the Pay Transparency Directive was just of a minor character. Secondly, what we also see is that the Pay Transparency Directive asks member states to take penalties which must be effective, dissuasive, and proportionate. And that is perhaps something, a trend, we may say, that we see on European level since a couple of years, and it all started with the GDPR, that not only takes Europe important legislation for companies, but this legislation has also been accompanied by important penalties. And also here, and it's also the case with, was also the case with the GDPR, it is mentioned that the member states can provide for the penalties that this is a percentage of the company's revenues or a percentage of the company's salaries, the total salaries within the organization. So important penalties are also to be expected. Next one that the Pay Transparency Directive includes is a principle of full compensation and reparation in case of an equal pay claim for victims, so that they can obtain full compensation, which includes not only recovery of back pay and bonuses and payments in kind, but the directive also refers to damages for a for payments or compensation for non-material damages, as for example distress because employees have not been sufficiently appreciated, and all other kind of moral damages. And it also, and that's an interesting one for the legal persons around us, also makes a reference to compensation for damages which are caused by one or the other relevant factors, which may include intersectional discrimination, which is a discrimination based on different grounds. So there it foresees that all of these matters, elements are to be taken into consideration for determining the compensation or the reparation to be granted to victims of equal pay claims. The directive also foresees that member states must make sure that litigation power is granted to organizations, associations, employee representatives, etc., who can prove a legitimate aim, who can then represent or support victims of legal claims. So we may expect some class actions there in member states. The Pay Transparency Directive also foresees that the courts can provide injunction relief, for example, order that companies must review their pay structures, because as a consequence of the categorisation directive also foresees that companies must install within their organization pay structures. Well, if those pay structures are on itself discriminatory, judges can order organizations to review them. And another, at least from a continental perspective, interesting point is that courts can also order companies to give access to confidential information, which goes very far, because we at the continent are not used to have discovery processes. Another measure that is provided is in the directive is that member states may decide that the procedural costs are for the employer, even if the employer wins the case, but if it is clear that the employee has reasonable grounds to make a claim, and for example, an employee, states the directives, can have a reasonable ground if the employer did not comply with the Pay Transparency Directive. So another consequence of not complying with the Pay Transparency Directive. And then lastly, but at least as important, is that the Pay Transparency Directive also foresees that this not complying can be a reason for losing public contracts. So I hope I made our point that it is very important to comply with the Pay Transparency Directive once implemented in local legislation. If we can now go to the next slide. So a lot of new things that go far that need to be implemented in local legislation by 2026. But I think, again, I repeat, our main point is you should not wait until 2026, because if you will wait until 2026, it will be too late, because a lot of these new measures cannot be implemented just in one day. They need a lot of preparation. And that is why we tried also to summarize some of our tips and tricks and advices for you to get started as of today. So the first point we would advise you to do is get it on the business agenda, spread the word within your organization, get your teams ready. We see from our clients that in most cases, the people that are working on the Pay Transparency Directive is a combination of people of HR, legal, but also finance. The next step is, of course, mapping what your obligations are. Do you need, or are you falling under the reporting obligations? Yes or no? But in any event, any organization will need to comply with the obligations that apply to all organizations. And that includes, first of all, looking at your recruitment processes. So you will need this taken into account, and I think as Ornella was highlighting in some of the member states, that will be also at least a cultural shift, that it will no longer be possible to ask to an applicant what the pay history is. So perhaps already consider not doing that to see and how your recruitment process will then work. Then also you may need to think on how you will provide the initial information about the pay or the pay ranges before the job interview, or otherwise before contract is concluded. So you already start thinking about how you will address this. Then, of course, also audit your job titles. Are they based on objective and gender neutral criteria? Also looking at your vacancy notices, is that the same? And also your recruitment processes itself, is this non-discriminatory, or is there no bias thinking in it, and so forth. So that is the first step, it's the recruitment. And then Ornella, you will give us some more information about during the employment.
Of course, Sophie, because you need to take into account also the review of all HR processes, and also you need to screen employment contract, the work rules and policies for confidentiality clauses. Indeed, employers may require employees who have obtained information on the average pay of other employees not to use that information for any purpose other than to exercise their right to equal pays. This must be agreed on a confidentiality clause draft properly. And also it is important to review all the HR processes, job classes, performance management and criteria used to assess the performance of all the employees, and how to assess also the skills of everyone to ensure they are gender neutral and objective. Then you need to review or introduce grading and job leveling methodology to group categories of workers performing the same work or work of equal value, as Tom was telling you before. You need to review criteria used to determine pay levels and pay progression to be sure they are gender neutral and objectives. Then it's also necessary to review criteria to grant a complementary or variable components, because the discretionary bonus may not be acceptable any longer in the future. Prepare and draft a pay policy with these criteria and the obligations concerning the right of information towards employees and employees' representatives. It will be also necessary to prepare policy for the exercise of the right of information of employees during the employment contract, review recruiting policies, as Sophie told you, and train recruiters with the new rules, and also prepare training of managers to this paradigm shift. Tom, do you want to go ahead?
Yeah, I can just speak about the reporting obligations. So I think now is an important time to look at what your gaps are. So as Ornella said, one thing is to identify whether your existing leveling is up to scratch. And once you're happy that it is, then carry out some dry run analysis, see what your existing pay gaps are, both at the company level, but also at the per category level, and start looking at what your potential justification reasons might be, where pay gaps are greater than 5%. Start building the evidence to support those reasons. You might want to think about market data, benchmarking data. You might want to look at whether any methods that you use currently are potentially biased and not objective. So, for example, overly relying on something like length of service, while it's potentially could be a reason to explain gaps, it's often that something like length of service can bias men over women, so potentially not be objective. But whether that's the case will depend upon the specific facts, not just at the organization, but within the type of job or jobs that you're looking at. So once you have done that, once you have some understanding of what your pay gaps are looking like, start developing a plan to try and remedy gaps that you can't explain. So will that involve bumping up the pay of certain types? Will that involve other changes perhaps?
Thank you very much. We will now move to the Q&A sessions. We have received many questions, so first of all, thank you to our attendees. I will start with a question for Ornella. Ornella, in terms of telling the employees of their rights to request the pay information annually, is it sufficient to mention in the employee handbook, which is sent to employees for acknowledgement annually?
I think so. I think that the employer can make this information and this procedure public also in the framework of the handbook. So I think it's fine. The procedure to exercise the right of access, the right of information must be precise, must describe exactly the steps that the employees are required to follow to ask information. So the means that they need to use to ask information, the kind of request that they can ask, and also the topics that they can ask. But I think that the handbook is a perfect place, and if it's updated and given year by year annually to the employees, is perfect to that purpose.
Thank you. And I have a second question for you. Are the reporting thresholds calculated by employing entity or by member state? In the circumstances where an employing entity has employees across several member states, are they added together or considered separate?
Thank you, Alessia. The reporting thresholds are calculated legal entity by legal entity. So there is not a sum of all the employees of an entire group, but all the obligations, because I saw many questions on that. But all the obligations that we mentioned are referred to single legal entity in a single country. So for example, for companies or for multinational companies with different legal entities in different countries, the obligations must be addressed country by country and within one country, legal entity by legal entity. So also the threshold for the reporting obligation must be calculated, taking into account the legal entity.
Thank you very much. I have a question for Tom. Tom, can employers have a pay range for the same level to help justify pay gaps? For example, marketing manager with 2 years experience versus 5 years experience, etc.
Yeah, so can you have a range for the same job? Yeah, absolutely, you can have a range, and many employers do. And could that range reference length of service? Yes, it could, but I think important here, particularly for length of service, to make sure that if you're relying on that as an objective reason, be confident that it actually is an objective reason. So it's very common for men to have longer length of service in a job or with an employer than women, because women have more career breaks than men. And so if you are overly relying on length of service, you may have built into your pay setting a biased reason, not an objective reason. So I think when you're doing the analysis, think of it in two stages. So firstly, look at what your potential reasons might be and consider whether there is any evidence of potential bias in them, and then only take through to the next stage, that the regression analysis that I talked about, only take through those unbiased objective reasons.
Thank you. And another question for you. Do we know how employees who work across a number of EU member states will be treated?
Yeah, so someone like that, an employee working across different member states, they'll just be an employee of whatever legal entity employs them. So, for example, someone is working for the French entity, they will be an employee of the French entity, even if they are spending time in Belgium, Italy, Germany.
Thank you. And a question for Sophie. Sophie, do we know when Belgium labor authorities will publish guidance on how Belgian companies adapt the EU directive? Is it this year, end of something for next year, or in early 2026?
Unfortunately, we do not yet know it, but what we perhaps just for completing the message is there is already implementing legislation in Belgium, but it is very, very short, and it only applies in the public sector and only in for the French part, but not for the private sector. And if we look at the legislation that has implemented for the public sector parts of the directive, it is actually a copy-paste of the directive. So far, it does not give us more guidance on how it will be done in the private sector. Perhaps more broadly, in general, there is not yet so many countries where we see that they have already advanced in an important way in the implementation. They are working on it. There is Sweden, who has already extensive implementing draft legislation, and also Poland. But besides that, I think most of the countries are still in the developing phase. But as indicated, as the consequences will be so important, our advice is to already start preparing based on the text of the directive and the obligations that we have seen here, because these are minimum requirements. So it means that it will in any event already apply.
Thank you very much. And another question for you. What if we don't have any employee union representative or work council? Are we obliged to form this?
Well, there is something around that, and because that is important for your joint pay assessment. And there the directive says that if you don't have a employee representatives and you have this gender pay gap of more than 5% within a category of employees, that then the companies must appoint employees who will then act together with the employer to proceed with the joint pay assessment. In terms of the categorization, there is also some reference to, because the text of the directive says that to determine your category, so to determine if work is equal or work of equal value, that the criteria must be agreed with the employee representatives if you have one, but if not, that it must include at least the 4 criteria that Tom has provided. So at several spots, there are some indications of what to do if you don't have employee representatives, because it's not because you do not have employee representatives that, in other words, the directive will not apply.
Very clear. Thank you very much. And a question for Ornella. Are there any rights for workers to see the same kind of pay metrics across countries? For example, if a company has multiple entities in Europe, can employees compare themselves to other employees elsewhere?
No, the right of access of employees is related only on the company, also on the company's organization, the employer's organization, and not also to other entities of the same group. So the answer is no, because the employee can only ask to have information on pay structure, on the average pay of other categories of employees who are working the same or working a work of equal value, only related to the same company, same employer's organization, not other organization or even of the same group.
Thank you very much. And we also
sorry, can I perhaps add to this?
Yes.
Perhaps one thing that I want to add here is that in terms of giving the evidence, their reference is made, but that is just to compare with your reference person whether or not you receive the equal pay. The directive foresees there, it's part again of the third pillar of the providing the evidence, that that the reference persons do not necessarily need to be in service of the same company if the remuneration element can be attributed to the same source. So for example, if you have a group policy or bonus policy which applies to several companies, then in terms of reference person to provide the evidence, there in that last chapter, it goes a bit across companies, but not in order to obtain information, but in order to provide the evidence. It's just an additional thing that I wanted to add.
Yes, thank you, Sophie.
Do employees have a right to get information on how the detailed criteria of how a job has been categorized?
Yes, of course, because employees can access information on pay structure and criteria used for the pay structure. And also employees representatives have a very wide range of access to information on pay structure and also on the criteria used for the categorization.
Thank you very much. And we have time for a last question for Tom. We have a broad banding with 30% between minimum and maximum salary. Is this sustainable? Do we have to move to small grades?
So no, I don't think you have to. So the key thing to think about is, why do you have such a big range? What's the point of it? The key is about having solid, objective explanations for any differences. If you can very clearly and confidently explain why the range for the job goes from 0 to 30% more to someone at the top end of the range, then you're fine. The problem is when you can't explain that, and when you can't say, well, why is one job within this category getting paid 30% more than someone else within this category.
Thank you very much. Unfortunately, we are running out of time, and our panelists didn't have enough time to reply to all your questions, which were many, but they are available to reply via email. So for any further question you might have, our panelists, you have here the email address of our panelists, and you can reach out to them. In addition, we have a variety of resources and insights on the cross-border employment rules on our website, so don't forget to check them out. And for more information on our webinars, you can visit the webinar section on our website to find all the past recording and download the slide decks. And while you're there, take a listen to our podcast, Talking Work, in which we talk about the world of work. Finally, I would like to thank everyone for attending, and thank you also to our panelists for their interesting insights. And with that, the webinar will be now ending. Thank you, everyone, and have a great rest of the day.
Bye. Thank you.
Thank you. Bye-bye.
Bye.